My name is Angelita Baez. I lead the International Advocacy and Litigation team at RFK Human Rights. We have the pleasure to co-host this conversation with three other wonderful organizations: the Center for Justice and International Law, CEGIL, the Pan-African Lawyers Union, PALU, and the Center for International Environmental Law, CIEL. Today's discussion will look into the challenges that environmental defenders combating climate change and its adverse effects are facing, but also about some of the recent legal interventions and initiatives that have been started in different jurisdictions on states' obligations in regard to climate change. This climate emergency that no corner of the globe is immune from. We now have advisory opinion requests on state obligations in regard to climate change that are pending before three major international tribunals. The request filed by the Commission of Small Island States on Climate Change in December 2022 to the International Tribunal on the Law of the Sea, and which focuses on the specific obligations for states under the UN Convention on the Law of the Sea to prevent and protect the marine environment from the adverse effects of climate change. We also have the request filed in January 2023 by Chile and Colombia to the Inter-American Court of Human Rights, which is focused on state obligations to respond to the climate emergency under international human rights law, and the April 2023 advisory opinion request from the UN General Assembly to the International Court of Justice on international obligations of states to protect the climate system from greenhouse emissions and the legal consequences when they have caused harm to the climate system. So we want to connect these interventions to the human rights implications of climate change and how they might bolster protections for human rights and environmental defenders. So to get us started, I'm going to pass the floor to our first speaker today, Viviana Krisicevic, the Executive Director of the Center for Justice and International Law, CEGIL, one of the most prolific and pioneering lawyers using the Inter-American human rights system to defend human rights, seek redress for victims, and shape international human rights standards in key areas. One of such areas includes precisely what brings us together today, the intersection between climate crisis and human rights. CEGIL was one of the driving forces that ultimately pushed the governments of Chile and Colombia to request an advisory opinion from the Inter-American Court this past year, and she will be sharing with us a bit more on the strategy and the expectations behind this initiative. Viviana, the floor is yours.
Thank you very much, Angelita, and thanks to the other panelists and the organizations that are sponsoring this discussion. We need to keep on reflecting about the issues and the paths, because we're all conscious that the climate emergency is bigger than any country, any sector, any issue, and we need to work together, think together, build bridges, create additional knowledge, and help accelerate the responses to ensure that in tackling the climate emergency, we guarantee the rights of all, and in particular, we mitigate any differentiated impacts of those that are in the situation of the most vulnerability. And while there are many paths charters by policymakers, communities, nations, and even conventions and international agreements talking about how to tackle and how to move forward on addressing the climate emergency, without those that defend those solutions and are able to come forward and join forces to speak truth to power, those responses are not going to be fruitful and move significantly forward. We know that there are many conventions and discussions about access rights to ensure the right to a healthy environment and nature and tackling the climate emergency. But we understand that there are no rights without the possibility of stepping up to defend them. And for that, human rights defenders are part not only of the pillars that should be in place to defend rights, but are the foundation of it. There are no rights if people cannot make sure that they don't suffer harm when they step up and try to move decision makers, communities, businesses in the right direction. We see that very clearly in our region, in the Americas. The Americas is a very difficult region for human rights defenders, understood broadly. Not only for human rights defenders, but also for indigenous peoples working and defending the right to nature, and the rights of their communities, as well as Afro-descendant and peasant communities working on these issues. The realities as well of the climate emergency in our region are very significant in terms of droughts and fires, displacement, the potential and incremental process of desertification of the Amazon, as well as the shocking numbers of human rights defenders under attack. So when we think about human rights defenders and the climate emergency and the power of law, we can see that laws are and local and international legal developments can be one of the many tools to address the climate emergency. But laws and rights are very, very powerful tools. They are an organizational tool for national and international communities of nations and peoples and even individuals. So when thinking about how to tackle the climate emergency in our region, with the disparities of our region, with the violence and with the limitations of the rule of law in some of the countries, we saw international frameworks as a possibility of stepping up the discussions and some of the roadmaps for the solutions to the climate emergency. Not as the defining tool that will solve it all, because there's so much to be done and so many discussions that will not only go through the legal channels, but the legal channels and the human rights framework also bring a distinct flavor to the discussion. It's a discussion about equality, about justice, about not leaving anybody behind, and thinking about future generations, thinking about disparate impacts, empowering everybody to be able to act and defend the rights of themselves, but also the rights of others. So we saw in the context of the Americas the possibility of addressing and encouraging states and those that have the standing to move forward with a request of an advisory opinion, because we believed that it could create a different type of discussion, not only at the regional level, but also at the national level in many countries. And also it could help bring together communities that sometimes have very, very different types of discussions about the same issues, and very different types of like common sense and assumptions and conclusions. So we see an incredible gap between the scientific community and some of the policy decisions taken at the international level, and how that permeates discussions and legal conclusions at the national level. We think that there's an enormous possibility of moving forward and creating more knowledge and creating a clear path that includes the wealth of and the richness and the wisdom of environmental justice and scientific knowledge and policies, but also human rights standards and the wealth of experiences of different communities. And so that's why we encouraged, along with others, several governments to move forward. And there was a possibility of of having these two, at the time, new governments stepping forward. And we created the bridges so that they would have a substantive discussion about the opportunity of presenting an advisory opinion and then engaged with them on some of the topics that could be brought forward for the process. And in January 8th of last year, Chile and Colombia submitted the request for an advisory opinion to the Inter-American Court on Human Rights with a very long text. We didn't expect that would be the result of the process. We thought that it would be a bit more less ambitious. And then the court in turn also moved forward with a set of questions for states and the community that are also very, very broad. And we can go into the logic of some of the questions and the expectations in the Q&A if you want. But I would underline that we see an advisory opinion within the framework of human rights, adding to some of the discussions, adding to the local discussions, adding to the interdisciplinary discussions, adding to some of the policy discussions that are very difficult internationally, and creating some language and a roadmap at those different levels. Obviously, some people think about them as accelerators of litigation. I think, having litigated my whole life, I don't see them as much as accelerators of litigation in the short term, because I think the climate emergency is so devastating that we don't have the time for a lot of the litigation that could take decades. We need to do some strategic litigation, but we have to use the spaces, the discussions, and the guidelines in order to accelerate the responses nationally, locally, regionally, and globally. So with that, I will leave my introductory remarks.
Thank you so much, Viviana, and you've been so great with managing your time. Definitely lots of questions that we'll get back to, including the pros and cons of such an ambitious and extensive list of questions that has been asked to the court to address through its advisory opinion. But I want to turn now to Luisa Gomez Betancourt, who's our next speaker. And she comes from the Center for International Environmental Law, CIEL, where she works as a senior attorney in its People, Land, and Resources program. Luisa is a Colombian human rights lawyer and has worked with civil society organizations, academia, and judicial institutions advancing justice for victims of human rights violations and environmental harm. Her organization has also been greatly engaged in the various advisory opinion processes before the International Tribunal for the Law of the Sea, the Inter-American Court of Human Rights, and the International Court of Justice. Luisa, the floor is yours.
Thank you very much, Angelita. Y muchas gracias por su invitación.
Thank you very much for your invitation. I would prefer to speak Spanish, although I speak other languages. I'm very, very happy to be here from CIEL. I'm very happy to accept the invitation and this initiative, along with the Pan-African lawyers, to be part of this conversation, to be able to discuss the different emergencies or climate emergencies that are costing us so much. The International Tribunal and the Inter-American Court, as has already been mentioned by Viviana, as well as the International Court of Justice. My name is Luisa Gomez. I work with CIEL, an organization that for the last 30 years has been working with law as a tool to transform and protect the environment and human rights. So, in two of the processes that I've already mentioned, on one part, Greenpeace International has a list of requirements. And as you said, Angelita, And on the other side, at the end of the last year, Cielo was working alongside international organizations in Latin America to work with the Inter-American Court, and one is related to the states in face of the corporate actors that are working with this climate crisis, with the defenders in the climate emergency. Also, we've collaborated with other people, and also on behalf of the initial collaborative. Currently, we're in a preparation with the different candidates and colleagues worldwide to take part in the process of cognitive opinion before the International Court of Justice. But there are other processes that are quite particular, which of course we will refer to at a later point. Substantially, we share the work of this process. The first, we find ourselves in a historical moment, not only because we never had a process of opinion in the face of climate change, but there are three parallel processes. So we have some sort of historical triad, and quite possibly more visible in Africa. I'm sure we'll hear about it later. This shows a clear symptom that there is a need of policies in different regions of the world to face climate change as a planet effect and that goes beyond borders. This triad opens a historical possibility also to make sure that the different courts around the world clarify and make sure that international obligations of all states and companies are made explicit under multiple bridges of international rights in the context of climate change, climate emergency, in regards to people. The second reflection that we wish to share is that despite the fact that it's we have to deal with three different tribunals who have to work with different legal instruments, we have a common conclusion. All these instruments and legal frameworks indicate that the states have a clear obligation and legal responsibility to the people, for the people, the citizen, as far as climate change. And if they do not meet them, they will have to face or suffer our consequences. These are contemplated exclusively in the Convention framework of the United Nations and the Paris Accords. It is very important to make a harmonic and systematic interpretation with the rest of the international rights. In Los Cusco, for example, we said to the Inter-American Court that the states with the pre-existing documents in human rights have to protect the rights in face of the climate crisis, and they also have a duty to help any of these victims. In other words, the precision and clarification that made by these tribunals has a lot to do and a lot to give as far as a response and face the different challenges of the countries and communities affected by the emergency, and that cannot be addressed immediately. And this allows me to move forward to a third general reflection, and it is that cognitive and politic opinions do not have the legal strength, internationally speaking. This means that they can be very useful for public policies, for strategic litigation, and of course, to make sure that the local and national judges have further resources for interpretation purposes and be able to build better cases in favor of the states in relation to climate emergency. And finally, I have a few minutes, Angelita. I would like to highlight some specific aspects. of the Inter-American Court and some of the documents that were sent that have to do with the environment security. With the colleagues of the Open Society College of University and the NNP, we've concluded that presenting the responsibility of the companies to the court is fundamental. And this is essentially because climate change is primarily affected by actions and incentives of a small number of companies, referred to as the carbon majors or carbon giants. So, in other words, the objective of sending these documents to the court and is to make sure that these companies are made responsible. And we have to address this, make sure that they understand the impact that this has on the global crisis. And it is impossible to guarantee human rights in the context of this climate emergency if the activities of said corporations aren't regulated or monitored. In this sense, I believe that science is a great ally, and I believe that the best way to mitigate the impact of the effects of climate change and the effects that it will have on human rights is to make sure that we diminish fossil fuels and accelerate its elimination gradually. We are providing several arguments to the courts to make sure that we have the obligation of the states to regulate corporate behavior, excluding climate. Secondly, to make sure that the companies have more direct and stronger responsibilities. And thirdly, make sure that the climate victims are compensated based on international standards. And finally, we also have to measure that CIEL with along with other organizations in Latin America, we were able to write a document to the court on behalf of several groups and organizations, primarily for clarification purposes in front of the court to make sure that everything meets the all the international standards. Hence, its ratification and implementation in Latin American countries are a priority, especially in a region who is currently in the eye of the hurricane, given that it is the most dangerous. We made sure that the protection of the rights of environment is not only a mandate for the American Convention, but it's also one of the essential ways to face climate change and make sure that the states comply to their commitments. And of course, to make sure to protect those who defend and protect the environment, the people who have a very deep knowledge of the territories of the nature and its regenerative capacities, the people who understand and know how to work the ecosystem. And this is exactly what we need to face climate change. So, to protect the defenders is highly important, and we need to continue defending their rights so that we can help the planet. Now, in conclusion, I believe that we have to make a transition, an energy transition that will change the exploitation patterns of industry, the legacy exploitation problems. So we believe that the energy transition must be brought to balance because they are very important for this climate change and for the human rights as well. So of course, we have to guarantee the rights once again for the defenders. And I do believe that although energy is necessary, it should not be used as a justification to continue harming our planet. So we need clean energy, not only for the sake of clean energy, but also for human rights. So once again, we would like to thank you for this invitation. And in conclusion, the importance of this moment, this is really a window for a climate action that is quite wide and much greater than us. So thank you very much. Angelica, you have the floor.
Thank you so, so much. And we'll get back to you on a lot of the points that you have raised, but I want now to pass the floor and introduce Don Aldea. Don is the CEO of the Pan-African Lawyers Union, and among other things, he chairs the executive committees of the Pan-African Citizens Network, the Stop the Bleeding Consortium, the Financial Transparency Coalition, and the International Coalition for the Responsibility to Protect. Don is an advocate of the High Court of Kenya, as well as a prolific litigator in the various African international courts and tribunals. Today, Donna will share some of the current legal initiatives that African civil society is undertaking on the field of climate change and human rights, including the possible request of an advisory opinion on climate change to the African Court on Human and People's Rights, as well as the broader implications of the other regional and international processes on this issue. Don, the floor is yours.
Thank you very much, Angelita, and it's a real pleasure to be here and to be able to exchange perspectives with colleagues from all over the world, especially my two co-panelists who have covered some of the work that's going on coming from Latin America, but also at the international level to ITLOS, the ICJ, and so on. I think we usually really benefit much, especially those of us from the global South, when we exchange ideas, exchange initiatives, and also collaborate to the extent that we can. As has been said many times, Africa is at least emitter of greenhouse gases, and yet is one of the most vulnerable to climate change, with an increased risk of drought, desertification, flooding, disappearing of some of the small islands, and so on. And of course, like my colleagues have said, the impacts are huge. We have human migration, we have displacement, we have food insecurity, water shortages, and the greater risks of certain illnesses. I think one thing that has not been pointed out, and I really like that colleagues from the Global Center for the Responsibility to Protect in New York had a different event on this yesterday, was looking at climate change as a contributor or a primary cause of mass atrocity crimes, genocide, crimes against humanity, war crimes, and ethnic cleansing. When there's fight over water, when there's fight over pasture, when there are conflicts between, on the one hand, pastoralists or people who predominantly keep animals for a living, and those who predominantly farm, when there's conflicts between communities which have lived their lives in a particular way, and big mining corporations which are displacing them because they want to mine, everything from the traditional oil, gas, gold, to these new rare minerals and critical minerals that are needed for the transition we're going into, lithium and so on. So there's a lot of war also being caused just around the intersection of climate and so on. So we're bearing all of this in mind. So like for PALU, which works across first on economic governance and economic justice issues, but also works on the more traditional civil and political rights, economic and social and cultural rights, we ended up approaching climate change and law from these two angles. And yeah, so we've been monitoring, of course, the developing requests, which my colleagues have discussed. And we've also been either actively litigating, supporting, or otherwise monitoring litigation in Africa that have a bearing on the climate crisis one way or the other. And this is in our continental courts and tribunals. That's the African Court on Human and People's Rights here in Arusha, Tanzania, and also the African Commission on Human and People's Rights in Banjul, the Gambia, but also the sub-regional courts. So for instance, the East African Court of Justice, which is also based here in Arusha in Tanzania, or the Community Court of Justice of the Economic Community of the West African States, or the ECOWAS Court, as we call it, which is based in Abuja in Nigeria. We've also been monitoring litigation going on at national level in various countries in Africa. So for instance, at the African Court here in Arusha, we've been engaged in what is called the Ogiek case for the last literally 8 years. The Ogiek are an indigenous forest living, mountain forest dwelling community in Kenya that were being evicted from their land very violently by the government of Kenya on the basis that they're destroying the water towers in the forest. And they went to the African Commission, and the African Commission appointed Palu to lead its litigation team to refer the matter to the African Court on Human and People's Rights, where we already have successful judgments, both on the merits and on reparations, but we're still facing challenges because the government of Kenya is not implementing the reparations, but is actually undertaking a fresh round of evictions. So we're still in court. We've also been monitoring in the same court a case arising from Cote d'Ivoire, the Ivory Coast, the Trafigura case, where the government allowed Trafigura, a European a multinational corporation, to dump toxic waste off the Ivorian coast. And the court has found the state at fault for failing to protect the human and people's rights in the instance. Similarly, you would find in the East African Court of Justice, again, in a series of cases, we're representing the Maasai from Loliondo and Ngorongoro areas, which is a couple of hours drive out of Arusha, where again, the government is using the example of climate change and the example of overherding of cattle to try and evict the Maasai from their traditional lands and displace them, for one part, to some coastal region, which is a very different environment from which they live in. And in others, they just want to displace them without caring. And again, we've won some court judgments, but we're also still in court on some. But we've also been monitoring a case coming out of Uganda where environmental NGOs from Uganda, Tanzania, and Kenya have been opposing plans to develop an oil pipeline that will get oil from Uganda going through Tanzania, especially in the Lake region, the Lake Victoria region, the Interlacustrian region, as they call it, all the way to the coast, because of the serious environmental impacts it is likely to have. And that matter is also still in court. And of course, there are a whole number of national level cases that we're also watching across the continent. So with respect to the prospective request that we're planning, Palu is leading the process of developing and hopefully soon filing a request for an advisory opinion to the African Court on Human and People's Rights. And we're doing this in collaboration with several sister organizations and coalitions, including Climate Legal Defense from the US, but operates a lot in Africa, Green Governance International, Greenpeace Africa from South Africa, Natural Justice from South Africa, Katiba Institute, one of the leading public interest litigation organizations in Kenya, the Zimbabwe Environmental Law Association, and Natural Resources Governance, and others. Legally, the request will be based primarily on the African Charter on Human and People's Rights, which of course is a universal human rights instrument for the African continent that has been ratified by 54 of the 55 states. It's only the recent re-entrant Morocco that is yet to ratify it, but it has near universal application in Africa. And we're also basing on several resolutions that has been made by the main treaty body in the African human rights system, and that's the African Commission on Human and People's Rights, and it has passed resolutions on climate change and human rights and the need to study the impact further on Africa. It has passed resolutions on rights of indigenous communities, on women's rights, including to land and productive resources, on the right to food and food insecurity, and on the human rights impacts of extreme weather in Eastern and Southern Africa due to climate change. So we're basing it basically on the African Charter and on the soft law of the African Charter from the Commission, but basically, of course, on the entire body of applicable international law, because the court is empowered to interpret, apply, and assure compliance with all international human rights instruments that the relevant states parties have ratified. So why did we want to go the way of a request for advisory opinion? Because as you can see, there are actually already some contentious cases, some that we engage in, our colleagues are engaged in, which bring out several aspects of the climate change issue, or the climate change phenomenon and its impacts on human and people's rights. One, of course, if you go the contentious way, you have to exhaust local remedies first. So we wanted to avoid a situation where you have to exhaust local remedies. Two, if you go the contentious way, the question is actually framed already and circumscribed by what was the violation in the specific partner state. Yet, if you go by the way of a request of advisory opinion, you can frame the issues how you want, so that they situate exactly what you want to address without hindrance. Also, we like the way of a request for advisory opinion because unlike a contentious case where a state or a group of states are already put on the defense, an advisory opinion is non-threatening. It is non-contentious. So our experience has been many more states are willing to actually participate, to open up, to give observations, to give their best practices, to highlight some of the challenges they're facing in a non-contentious manner. So it encourages states to participate progressively. And again, the request, although this is there also for contentious cases, but the court has a much more lenient approach to amici curiae in a request. It tends to be more open to hearing from a range of actors, not just from Africa, but from across the world. And it actually often proactively reaches out to organizations and tell them, would you like to submit an amicus brief on this question that we are considering? So lots of other actors, academic institutions, think tanks, civil society could then be able to participate. So at the moment, we've been at a stage together with the coalition of CSOs, civil society organizations that we've been working with. We've done a lot of ground research. We've done comparative analysis across the continent. We're looking at what's going on in the other continents and in the other international courts and tribunals. So we are now at the drafting stage. And we're taking lessons learned, like for instance, from the points that were made, especially from the lessons learned from the Inter-American court process. In terms of how do you frame the questions, the things Luisa was speaking about, what is too broad, what is too narrow, what's the right mix? At what point do you, hit the point of the law of diminishing returns? So we hope to file in the next couple of months. And then the court then, of course, will notify all the states parties and will invite observations from them. It'll probably accept observations from other amicus curiae and so on. And then it'll make its decision. But for us, it's very, very important. Two things: movement building. Litigation is not that impactful if it's sought on its own, but if it's part of a larger movement and a larger group of strategies of people trying to do something. So we're engaging in continuous movement building and also communication, making sure that we communicate each stage of the process and engage the public and the governments in an interactive dialogue, a two-way, so that we maximize the impact. And part of the communication in the course of the African continent is to tell them that Africa actually has a protocol which hasn't come into force, but that would give an international criminal jurisdiction to the existing African Court on Human and People's Rights. So this court then would be able to tackle a whole range of crimes: genocide, war crimes, crimes against humanity, but also environmental crimes, illicit exploitation of natural resources in Africa, which is a big area for us, and also trafficking in hazardous wastes. So we're not being too ambitious with this one request, but we're locating within a larger movement, moving in a particular direction, especially on climate and environment. Thank you. Let me stop there.
Thank you so much, Don, for this overview, and it's really interesting to hear what the thoughts and the strategies behind this initiative to also file a request for advisory opinion, and also taking advantage, which is not the case in other regional systems, of such requests, the ability of having those requests come from civil society and not necessarily through a member state, no, which is not the case in the Inter-American system. So going back to the Inter-American system, and now we are officially opening the Q&A section of this webinar, but I want to start by asking a question to Viviana, and going back into the request that is of advisory opinion that is currently before the Inter-American Court on Human Rights, and which really is, as you described, very ambitious. No, we have before the other two tribunals that have ongoing, currently advisory opinion requests under consideration, they each have 2 questions. No, they're big, they're broad, but they're 2. Whereas with the Inter-American system and the court, there's 18 questions that also each have a few sub-questions. So you get really a big amount of questions addressing a very large array of issues. Of course, as you describe, and I think it's a fantastic way of putting it, it's, bring that human right, that flavor, or that the human rights framework, bringing that flavor that is necessary in conversations about how to address and the challenge that is posed, and the threats and impact of the climate crisis. But is there any, any thought on the risks, the pros and cons of having such a broad array of questions under consideration right now by the court?
So I have to say that from a global perspective, it seems even more ambitious than in the regional perspective, because if you look at other requests for advisory opinions in our region, they also have many questions. Here there were 6 topics that were identified as key topics, and each topic has 2 or 3 questions that further develop each of the topics. Some of those topics can be joined together, like general obligations with reparations, and so they could have been framed differently. I think that many of the states that have put forward advisory opinion requests see them as a one-shot thing. It's not going to happen that you're going to have many advisory opinions on the same issue over many years. And the court had already gone very broadly on issues of the environment and human rights. So here was like turning the gears and focusing in applying some of those standards to the climate emergency. And there is a gap. There is a significant gap, I think, a significant knowledge gap in the development of standards. If you look at international environmental law, international human rights law, general international law, some of the local developments, and how they apply to key areas, as it was very well explained by Luisa. It's just some things it's just application of existing standards. Something is building knowledge together. So many of the aspects of the advisory opinion request are ambitious, but are about applying human rights standards to environmental issues or environmental acknowledgements. So, for example, in international law, in different agreements, at the COPs, in the subsequent statements and made by scientists, the Intergovernmental Panel, nations, with the inequalities of the treaty drafting process and the agreements created by international inequalities, there is a recognition of some of the thresholds that shouldn't be surpassed, but not necessarily of the human rights consequences that they have. First of all, because some of those treaties are environmental treaties and they're much more reluctant to address the human rights consequences. But in the human rights field, it is very clear, very well established that when you have knowledge of an immediate risk to life, integrity of rights that is urgent, you have a set of due diligence obligations to prevent that risk from happening. That has to have consequences for surpassing 1.5 degrees of pre-industrial temperatures. So there are things where the law was there, it's just a question of applying it, and there are areas where applying human rights standards and thinking about the knowledge and the agreements in this field with these tools brings something different. So we wanted to make sure, I think the governments and many in our community, that some of the consequences, the legal consequences that cannot be discussed in other fora, or can be discussed, but they cannot be agreed upon in other fora, are very, very, very clear seen through a human rights framework in terms of the nature of the obligations, the consequences of the obligations. And so that's a big part of it. Issues such as Luisa talked about fossil fuels, and for example, I don't know, the issue of what to do with methane. No, there's a lot of common sense knowledge among scientists and international environmental discussions and policy discussions about the importance of tackling methane. But who in the human rights community has heard of methane? Or the judges that are handling these issues or thinking about strategic litigation and thinking of points of entry. And so many of the discussions that Luisa brought about and that Dawn brought about are areas of discussions that join some of the practical consequences and the challenges on the ground and the wealth of experience of different communities that need to be seen through a human rights lens to give it consequence. So, and we have done that with the fight against enforced disappearances or violence against women. So the human rights framework has tackled issues where it has to set priorities and establish due diligence obligations. And it can do it in a much more detailed manner for part of the framework of that is necessary to further develop from a human rights perspective because of the rights that are at stake in terms of equality, life, health, etc. So what we did with the process, I mean, in terms of framing the questions, the questions are of the advisory opinion of the Inter-American, that the Inter-American Court is moving along. It includes issues of general obligations, of access to information, but also proactive production of information necessary to address human rights, the protection of human rights and reparations. There's a whole section about indigenous peoples, which is critical, about human rights defenders, about disparate impact and the rights of children and future generations, and about differentiated responsibilities, obligations of cooperation, solidarity, reparations. So there are several broad issues that the court will have to deal with. The court then could have a 500-page advisory opinion or a 100-page advisory opinion. It depends a lot on how poignant the court will want to be, how crisp does the court feel that it has to be in order to permeate some of the discussions and clarify some of the obligations. We believe that the advisory opinion process is important for movement building, as Dawn said, but we also see some of the gaps and the needs for interdisciplinary and stakeholder conversations. You know, that's very, very critical. So we worked together and tried to be very proactive in sharing the information about how to participate with many, many organizations, as has been done by Ciel and others and RFK, and in making sure that people know how to participate. But then we decided to try to engage, and Angelita knows this very well because she was part of those discussions, in much more in-depth conversations about each of the substantive issues raised by the court, and created like a whole process of doing research and trying to bring people together and working on the different standards and consequences for each of the issues. Plus, we worked with two groups of scientists, like an umbrella group of scientists that gave input at different junctures of the scientific information that we needed to take into account in order to tackle some of the legal issues. For example, on attribution science, I mean, things that is not part of the bread and butter of the human rights field necessarily, but it's important for the development of the law. And then we worked with some scientists that worked on the health implications for children of the climate emergency. And we worked with some indigenous peoples as well, and with indigenous environmental leaders. And we fostered discussions and participated in discussions with youth groups, but also with children, which was really fascinating. I loved that part of the experience. And now I think we actually made through the amicus briefs, I think, significant steps forward in the building and the creation of new knowledge, as well as in the process of expanding the community. So, for example, one of the areas that I'm very happy about is on environmental human rights defenders. Another area that I'm also very, very happy about, the developments of the law, deals with the obligations to proactively produce information in order to tackle the climate emergency, and what that means in terms of our region. And there's some information that comes from Escazú with guidelines, some guidelines that come from the jurisprudence of the court. Many of the cases that we've litigated include the obligation to proactively create those systems, data systems, and publicity for important parts of that information. But also there's a lot of information where there are obligations that derive from environmental treaties, that also has to be weaved into defining what is the minimum, and not only having transparent policies, but also producing the information that is key domestically and internationally, and what are some of the things that need to be done at different levels, at the regional level, at the global level, and obligations to cooperate with information as well. So I'm sorry I'm extending too much the response, but I'm very passionate about this, and I think there's so much to discuss. So, but I'll leave it there.
Thank you so much, Viviana. I mean, one of the things that I wanted to ask you precisely was, especially looking in retrospect and acknowledging that the court has not yet issued its advisory opinion, but from the process so far, like what advice you would give our colleagues in Africa, like Dawn, that are leading these initiatives to also request an advisory opinion? I think you mentioned some points that also Dawn raised as part of their current strategy, including the efforts to really make sure that there's a wide participation and consultation with civil society, and that communities and different stakeholders are aware of the process and the potential of it. So we can.
I loved what Dawn said actually about conflict, you know, and about, not because I love what the consequences, obviously, but being really true to your reality. So we've tried to do that always in our work, but sometimes you can see dimensions of the problem and the solutions with these types of processes. And I think that what Dawn was explaining about Africa, you could see how he was not coming from like a top-down thing of, okay, these are the problems, this is how you solve them, but it's truly, it gives it so much more depth and meaning to the diagnosis, but also then to the solutions. And so I think that being true to that is very, very important. Being interdisciplinary and understanding that in different countries, things might be different is important. I would have to give myself a piece of advice that I seldom follow, but it's like try not to do the perfect job. Sometimes the process is important, and for some of these things that we're gonna be doing, this is not going to be the end line, whatever we do in terms of the questions or the amicus. Is going to be part of a process. So I see everything that we've done so far as part of a community as moving ahead, and then now we need to keep on working together and crossing more some of the knowledge and the information, so do not aspire to be perfect with the briefs as you would do for the Supreme Court or for a trial, but it's going to be a different process.
Thank you, Viviana. And before I turn to Dawn, I just want to remind the audience that we would love to get your questions. The system that we have set up in place is you can ask your questions in writing through the Q&A function of Zoom. So please don't be shy. We still have a bit of time, and hopefully we can get through at least some of those questions. But I'll turn now to Dawn. And I mean, one of the things that you mentioned, and it's been coming from different sectors of civil society in Africa, about how some of the climate crisis responses, quote unquote, because some of them don't seem like very good responses, are actually endangering further already vulnerable communities, or are actually causing more harm in a way, violence, etc. There's also some sectors that talk about a wave of green colonialism that is particularly impacting Africa, with global north countries now trying to exploit again, or continue exploiting the resources in Africa and other parts of the world, but under the guise of, we are greening our energy, so we're doing a good thing. Can you comment a bit more on that and what you've observed in the continent, and also, if you may, also address a bit the impact on civic space around climate change activism in Africa?
And do that. Yeah, and I also just like to acknowledge that I've seen in the Q&A the question from Batseba Seifu, who actually gives more examples of how war actually itself destroys the environment. When you look at issues like, bombardments, aerial and, ground bombardments, when you look at things like vehicular movements and how they affect forests and affect conservation structures, and restoration structures. If you look at the use of dangerous chemicals and weapons, and then if you look at the waste that will remain and abandoned military material and so on, and also stuff like that the soldiers will actually steal your crops, steal your livestock and so on, leave you more vulnerable. So I acknowledge that too. And yeah, part of what we are also confronting, even as we do that, is what you're calling the new green colonialism. And in the African context, it's very interesting that it's coming from two parts now. It's coming from the global north, but it's also coming from the Gulf. So in the United Arab Emirates, there's a new company that was registered just last year called Blue Carbon. And this Blue Carbon is owned by one of the princes, you know, immediate brother or cousin of the king of the Dubai and so on. And they've been parachuting into several African countries, Kenya, Tanzania, Zimbabwe, Zambia, Liberia, you know, and so on, and negotiating with our governments to help them with this so-called carbon trading and signing off, and our governments are signing off huge swaths of land, especially forests, to this company already. So the land that currently they own or that is under their care, their management, it's the equivalent of the size of Kenya. And you know, Kenya is not one of the smallest countries. And it's all been done in the last 12 months by a company that's less than 2 years old. It is not known, you know, and so on. And this is part of what was being showcased, you know, at Dubai. So we're seeing what's happening with the global north, but we're also seeing what's coming from the Gulf. And a lot of our people, it's happening so fast, so that a lot of our people are not seeing it, you know. So it's in the last 3 months that environmental defenders, campaigners, lawyers, groups, and so on have been trying to raise awareness of the people. And then for countries where it is allowed, because a lot of these deals are also shrouded in mystery. You know, you just see an announcement that so-and-so, you know, signed off, you know, these forests. Those forests have people living in them or near them, earning their living. That's the only place they know. That's the only place they come from. But you realize you've been sold off. So it's almost a second round of slavery or a second round of colonialism, where some of our leaders, for selfish interests, signed off treaties without the people knowing that they were being sold off. So that's one of the big issues we're dealing with. In a number of countries, we're encouraging our countries, our counterparts in country where they have access to information laws, to at least begin applying access to information requests so that we can have a sense of what's really going on. And in countries that have statutory requirements for public participation, to begin to challenge these deals as null and void because there was no prior public participation and there's no public participation anyway. And of course, in countries, dualist countries, where deals, including international treaties, have to be ratified by the legislative, by parliament, to begin to engage parliamentarians, at least in the exploratory part. We do know the risks because with these kinds of big deals, the retaliation when you question authority is very, very heavy. We're dealing with that, including in Tanzania now, where we were informed by a whistleblower, or the people were informed by a whistleblower, that the head of state and the government had entered into deals to manage ports with the same Dubai, deals that are clearly one-sided and unconscionable and did not inform or inform the public. And anybody who's questioned, journalists, even former politicians and diplomats. We have a diplomat, a retired ambassador, who was stripped of his ambassadorial title. We have journalists who are arrested on trumped-up charges. We have lawyers who are defending those journalists, who themselves then are also kind of put through, you know, intimidation using the disciplinary process of the legal profession as though they are done infractions. And then lawyers who go to defend them there in the disciplinary process of the legal profession, themselves being put through suspension, you know, without due process. So the risks are many, and even part of the conversations we are having with some colleagues is not just look at human rights defense as a whole, because we've been doing that, but to create specific parts for defending journalists, journalistic human rights defenders, and to put specific parts and programs for defending environmental human rights defenders within the larger rubric, so that there's more action on the ground and there's a bit more specialization and especially anticipation. So in our lawyers groups and in the networks that Palu runs, we're telling people, if you know you're going to launch a big campaign, or if you know you're going to file a significant case, where possible, please tell us in advance so that in the movement, we're kind of prepared. So should repercussions come, we're not scrambling after the fact, but we had kind of anticipated it. We had done, a risk assessment. We had come up with some standard operating protocols. We have people on standby and so on. But I agree. I know even in Latin America, because we do read, it's not an easy time to be an activist in the field of the environment and climate and also extractive industry. The other thing I would say, and I think this touches a bit also on what Viviana said, a lot of these things are very new. A lot of these things are very new. So many times, for instance, the judges, when you take to them an issue, and we see this not just in this climate and environmental work, but also in some of our economic governance work, like illicit financial flows. They are floating when it comes to the complexity of the thing. So many times then they try to give you the order that you want, but on procedural grounds. Like they would strike down a deal and say there was no public participation, but they would not go into the merits around what was the quality of the agreement. Did this agreement meet our constitutional whatever and so on? So it also just brings out the need to engage in a lot of training for judges, for prosecutors, for the media, and so on, to understand some of the complexities of this new world we're going into. Thank you.
Thank you, Don, so much. And I think that what you mentioned about the need to prepare, like the anticipation of backlash and consequences against those that are at the forefront of combating climate change and protecting those that defend human rights in this context is really important and very applicable to other regions of the world, including, of course, the Americas, where I think that those self-protection measures and strategies among civil society organizations of having, plans before launching big campaigns or filing big cases that may result in such backlash is really important. I would like to go back to Luisa now, and then and to the point of participation through amicus or in other ways in these ongoing advisory opinion processes. And in particular, especially when we compare the accessibility that the Inter-American Court has when it comes to allowing intervention and participation from many stakeholders and civil society organizations and other participants. And we saw even the court extending its deadline for stakeholders to submit their amicus curiae briefs. I would like to ask, when it comes to the International Court of Justice, we know that in principle, at least, there is no possibility, seems, to intervene through amicus curiae for NGO, civil society. What are the thoughts and strategies that you could share you're working on from CL and with other partners to try to ensure there's broader participation in that particular process?
Thank you so much, Angelita, for that question. Sí, efectivamente hay una diferencia en el
Yes,
acceso.
effectively, there is a difference in the access. And in the International Court of Justice, and we compare it to the Inter-American Court of Human Rights, and there is a reason behind this. And we aspire by the nature of the tribunals, and I would like to share a few words before I go straight to the answer. And this is in the effect of sharing with the people that are here with us the nature of the process before the International Court of Justice, its relevance, importance, the strategies, and the challenges. The process of emergency climate before the International Court of Justice, as any regular process that is presented before the International Court, is seen as a large relationship between states. The difference, of course, is that the Inter-American Human Rights Court is not related to the states, but it has to do with a vertical relationship between the states as far as protecting the rights of the citizens and the people who are under the jurisdiction of the American conventions. So there is a relationship that exists, but said relationship is much more vertical. This, however, does not mean that the International Court of Justice and its processes are less important. As a matter of fact, it's very important and has to be seen from another aspect, another point of view. For example, there are states from the Northern Hemisphere who are much more responsible as far as their contribution for climate change if we compare them to the Southern Hemisphere. So in this case, the International Court of Justice will allow us to explore these different responsibilities, although shared, but very different between the states from the Northern Hemisphere who actually comply in a relationship to the states of the South Hemisphere and speak of the consequences and the responsibilities that they should have to make sure that they copy the best practices of the North. And this is the scenario in which we believe that the international court will be able to speak and help us speak among different states. So I believe this to be very interesting, and this will give us a better idea as to why this process before the International Court of Justice is highly important. And of course, I do believe that we have to keep this in our radar. Now, following the same nature, this is where we see the challenges, given that the court will be speaking to the states and is not speaking to the citizens, the people, the indigenous people, civil society, nor the communities. For the very same reason, those who have to work to take part of this opinion process with the states, as well as other organizations, must be authorized by the court itself. Obviously, there is a regimen that needs to be placed because there are many other voices of social society, indigenous community, and other local communities who are directly impacted by climate change, and they're very vulnerable. And these people do not have a voice; they cannot participate directly based on the rules of the court. So, of course, from the civil society, we're attempting to find a way to ha to find a way to make sure that they take part. And up until now, we've explored several strategies. One is via friendly states. Some states are, let's say, quite close to civil society or have some sort of affinity, let's say, as far as environment defense, as far also as ensuring that the voiceless and the most affected communities have a voice and a platform, especially in the face of climate change. So these are people or these are states that are friendly and that are very helpful and very willing to highlight the profile of and raise the voices of the voiceless. So this is a strategy. A strategy is to contact these friendly states and the delegations that can present the different possibilities to send documents, information, and access elaborated by the civil society in regards or in favor of the indigenous people. Of course, this all depends on the relationship that exists between civil society, states, and indigenous people, which unfortunately, this relationship is not always the best in many countries. But there are governments that perhaps could be a bit closer to this possibility. The second possibility could be to propose to the court a reform to the rules, the procedures. This would allow other actors, such as civil society and others, to send their documents, their essays, and to at least have a public voice in a scenario that could be easier to see. online, for example, something that would help them get there more directly in the eyes and the ears of all the party concerns. This alternative, of course, has to be promoted, but it has to be promoted within the state. And we believe that although there are some states are friendly and they can be very close to this ideal or this type of proposals, especially states such as the states that are part of the Commission of Small States. Some we believe that they will be very close and helpful with these proposals. Now, the third alternative would be to send directly the amics to the courts and simply see what happens. I know it sounds a bit silly, but this would be some sort of a Russian roulette, if I may say, because of course, the very first thing that we must know is they will not be taken into account officially. So basically, within the file of the process, they're not going to publish, and they won't be seen officially, and hence they won't be considered as legal elements. However, this doesn't mean that the people don't have access. This means that the bridges, perhaps, that are being built can be used as elements, as element to generate debate and as an element to inspire in order to build cognitive opinion. These can be sent, and perhaps these could reach the ears and eyes of someone who cares. The fact that it's in the file doesn't mean that it will not be taken into consideration in the internal debates, the judges' internal debates. So we really need inspirational bridges. We need knowledge bridges, and I believe that this is the way to move forward. And now to conclude on this point, Angelita, there's a very interesting issue. It's an issue that is being explored, and it's explored with other organizations that work with the indigenous people. And we're sending a petition to the International Court of Justice to allow us, with the indigenous people, to take part in the same level of the state, understanding that they are indigenous, they are a people, and they are human. So this is an alternative, and this is an alternative that is resonating in several groups, especially, of course, the indigenous groups. And this is primarily because it ratifies a sovereignty and the right, of course, of the indigenous people, uh, and their right to self-governance. So presenting them as such instead of just another organization. But of course, we understand this will require a little bit more time. And so far, we have until March 22nd. That this is that's the limit for us to send the alternative and all documents. That is the deadline. And of course, it will all depend on many things, including the sovereignty of the indigenous people to accept and to understand how important this is for them to be able to take part in front of the International Court of Justice. So we're hoping that they understand all the ramifications that this may have in time. Positive, of course, from a political aspects, but we also understand that there are others that are negative. And that's it for me. Thank you. Thank you very much, Lisa. Very, very interesting, all the strategies that are being considered. And I believe it would be fantastic to see how the court responds to this. And now we have, well, we have very little time, but I really want to ask because we have many questions from the audience. And
Speaking in English, but Spanish just flows so naturally. I want to go back to some of the questions from the audience, and there's a couple that are specifically for Dawn, and I would like to maybe in one, because we have a little bit of time, but not much. Don, if you could maybe address the questions on, there's two, they're not the same, but talk about best practices and strategies that are being implemented in Africa. On one hand, to combat artisanal mining, impact on the environment, and modern day slavery and conflict that ensues very often. And also in regard to the unique or particular vulnerability that sexual and gender minorities face in the context also of climate change. If there's anything on those two fronts that you'd like to share with the audience.
Okay, thank you very much. Bearing in mind that there's very little time, I suppose that this probably will be my last opportunity to talk. So I was just trying to see also the question or the comment that has come from Fiona Eilif. I think hers is more of, if we're to take progressive or propose to the African Commission on Human and People's Rights to adopt progressive environmental rights frameworks such as Escalzo, what is likely to happen. So yeah, with regard to the first question, I'm sorry, David, that I just don't have it at at my fingertips, but I do know that the African mining vision and its implementation plan of action actually do address the issue of artisanal mining and providing best practices around artisanal mining. So I would say that that would be a good starting point for us in terms of what to do it well, and how to protect especially the small communities, especially the host communities, who many times are sidelined in favor of big mining conglomerates whose benefits, if any, are enjoyed in the capital city, and as much of it as possible is then externalized from the country by what we now frequently refer to as illicit financial flows. So I would go there with it. And of course, underlining the AMV, the African mining vision in the first place, is the importance of not having just a legal license, but also having a social license, so that negotiations actually involve the communities and the benefits go to the country generally in terms of structural transformation of the economy and not just extraction, but also ensuring that enough goes to the immediate community, the host community, which many times has been displaced by the big miners. With regard to what would be some best practices, this is an area that first, I agree, this is a major rights issue. It's not necessarily an area of my competence that I'd be able to say at the top of my head, these are some of the best ways. But I definitely do admit that it is a big issue that there'll be the intersectionalities and then how they will affect sexual and gender minorities so that they can then be addressed in that way. And Fiona, on your last question around the challenges faced by environmental defenders, I would say, and whether I think that the African Commission on Human and People's Rights, surprisingly, by the way, I mean, part of the challenge we're facing, and you could see that both Luis and Vanessa talked about it, is when you have this fast approach to the court by way of an advisory opinion, what do you put in, what do you leave out? So one of the big questions was on the table also, should we have a specific question addressing environmental defenders? So the final decision has not been made yet, but it's a big question around, should that be one of the key things or one of the questions that we ask in our draft request, so that the questions are not too many, but they're not too restrictive. Of course, generally we had adopted the approach that it's cumulative. We'll get answers to this, and we reserve the right to go again to further develop or to take another aspect. But it's a question there. But I do agree that I believe that the various special mechanisms of the African Commission on Human and People's Rights, the Working Group on Extractives, the Special Rapporteur on Human Rights Defenders, and so on, I think we can structure something specifically and work towards it for environmental human rights defenders, and we will get somewhere. Thanks. Let me stop there for now.
Thank you, Don. And I'm going to ask one final question that is both for Viviana and Luisa on insights in regard to the Escazú agreement precisely, and you know, in practice since its adoption, you know, do you see any advances, any benefits? What are or what can we do about the gaps in knowledge for communities regarding the scope of this particular agreement? I would say if we can try, I know it's a big question. There's a lot to say about the Escazú agreement itself. We could have a whole other webinar only on that. But if you could just share a few insights in 2 minutes each, that would be fantastic. Thank you.
Claro, Angelita, muchas gracias. De pronto puedo empezar muy rápido antes de darle la palabra a
Yes,
Viviana.
thank you very much. I'll go ahead and answer very quickly before passing the microphone to Viviana. I would highlight two advancements that we have to pay attention to very closely. First, the committee for the implementation for the CAFU agreement has already been made, and it started functioning after this year's COP, which will be in Santiago de Chile. As of May of this year, for some countries which have already ratified the Escazú agreement, it's only a matter of waiting to receive their petitions, their requests, actually, their individual requests. So this makes everything very, very interesting, because the mechanisms that they've planned to be able to, let's say, to continue with the agreement, I believe is a very important investment. But I think that it would be best if I send an email with a better and more detailed answer. So as far as the Casu in Santiago de Chile on April, we will see the approval for the action plan that have to do with the environment affairs. And this is something that we have to pay attention to, because this is a regional plan that would allow us to follow guides to all the countries that are ratifying these laws to make sure that they implement the action plans.
Muchísimas gracias. Y creo que para terminar, Escazú,
Thank you so much.
una bandera muy
This is
para
very
la comunidad de
important
derechos humanos
for
y
the
la
community of
comunidad
human rights and for the environmental community as well, because it's one of the communities that is more affected in Latin America, and still they need to develop in a bigger measure some of the institutional aspects, and also to create the juridical standards. And that's why for the future, it's very important to work to strengthen the process that is being carried on about the standards and the process, and to be able to integrate this transition in a very positive manner that we could do it with the standards of the American court, to be inclusive in some of the process, legal process and juridical process as well at internal level. And there are several areas where we could have a very positive interaction among these persons and the documents, like with the defenders, the positive production of information that is very important, and to implement this information with different standards, higher standards, lower standards, but very precise systems. And we should carry on that job that is so important. And I think also one of the participants have asked about the possibility to use Escazú in process of internal litigation process for different treaties, and this could strengthen the international architecture and the work with the Inter-American system and the policies at internal level. And with the liturgical level, the person who asked this question and what will be my recommendation, as Dawn has said, we don't have to do it alone. We have to think very well about the communities, how they have been affected, and we have to consider the dynamic of the climatic case, and we have to create the right strategy so that we can understand the communities. They are very rich and they can give us so much feedback, and we don't have too much time. There is a lot of needs. So there is the call there to create this action, not just to have homogeneous strategies, but to think very well before we launch these strategies. And that's all. Thank you so much. This has been a very enriching discussion.
But thank you, Dawn, Luisa, Viviana. Thank you also to our wonderful interpreters for allowing us to understand each other across the frontiers of language. We have come to the end of this webinar. Apologies for not addressing all the questions, even though this amazing panel was very helpful in flagging and addressing on their own some of these questions. I just want to end by inviting you all to check our previous webinars. This is part of a broader series of webinars on human rights and civic space. You can find them on our YouTube channel on very critical issues, including the right to protest or the situation of women journalists and gender-based violence against them. Yeah, thank you all. Have a great day and see you next time.
Thank you.